Good morning, Corey Ingber&Weinberg, 3 minutes with Ingber&Weinberg. It is Thursday the 27th, and I just want to recap on the COVID rules and how they are impacting our practice. I won't delve too deeply because of time constraints, and I know you've been deluged by this information since March, but remember, the governor's executive order N-3320 is still in place. It was issued on March 4th and it's still in place. That's the so-called stay-at-home order. So that's the foundation of the platform for the WCAB rules which follow. Then we have the governor's executive order N-6220 issued with respect to the presumption of COVID-related injuries resulting from an exposure where the employee was directed to work in the employer's workplace. That's a rebuttable presumption, and that will take effect for exposures from 03/10/2020 through July 15th, 2020. Now, in the legislature, we have SB 1159, which would codify that. That would actually make that a black letter law. On top of which, there's a secondary bill tied to that bill, which would in effect create a second level of presumptions for those employees who were working at their employer's place of work where there was a COVID outbreak, and therefore there would be a presumption. That's still in the legislature. It's in its second or third reading. I think it'll pass, and they amend it quite often, so expect that to see the light of legislative day. Then we have the WCAB. Remember, we're doing our status conferences, our MSCs, and our expedited hearings on a direct telephonic line with a judge. But as of August 17th, the WCAB now has the capacity, at the discretion of the judge, to allow you to have a video trial, which means you got to get your witnesses ready, and they have to have the software or the application to have access. So the video trials start on or after August 17th, 2020. And then we have the QME rules, don't forget those. We have Emergency Regulation 46.2. And by the way, I do have notes. I am cheating. I'm not that memory bound. But 46.2 suspends 31.3. What does that mean in non-legal speak? It means that the time frames for the QME to schedule the initial examination are extended by 30 days. So pre-COVID, it was 60 days if they were, or by agreement up to 90. Now it's 90 by agreement up to 120, and the 120 can be suspended upon agreement. And then they have the telehealth exams, which are only allowed if there's an agreement, there's an AOE, or end of benefit issue, and it's ethical, and it's also viable that a physical examination not be necessary. And then finally, the QME rules relating to the reports from the QME. That's been relaxed by 15-day addition, so the initial report is to be sent out within 45 days rather than 30, supplemental 70 rather than 60. Anyway, this has been a technical one. I'm sorry about the technical legalese, but it is what it is. One pointer and practice tip before I end: if you're an attorney or if you're a claims examiner, try to get the cell phone and email of your appearing adversary. That often promotes not only a good relationship, but allows you to actually deal with the issue before you call in the cattle call. Because remember, when you're calling in, everybody else hears you. And it's just better to have an agreement and a disposition ready when you do call in. We'll be doing our end of the month newsletter covering the legislation, including 1159. If you have any questions or comments, please contact us. Stay healthy. God bless you, and thank you very much. Thanks.